December. The Silchar Municipal Corporation issued a eviction notice
When do you want?
on the 3rd of November.
3rd of
3rd of August,
eviction?
my lord. Eviction and demolition. Monday, my lord.
Eviction, does the matter come before me or bench 5? Bench 5 matter.
Bench 5 matter.
Okay.
My lord, I want tender matter, my lord, very urgent matter, Monday, my lord. Public.
My lord, a motion item today, my lord, unlisted, my lord. There are 6 shops.
Huh?
There are 6 shops, my lord, who have been deprived of the electricity since 24th of last month. Yesterday, the APDCL confirmed the inability to provide electricity connection, my lord.
Electricity?
Yes, they're occupying the premises, my lord. There are prima facie grounds, my lord, for your lordship's interference. They did not.
Tell me again what has happened.
My lord, there are 6 shops.
Shops.
The electricity has been disconnected by one private individual who happens to be a family member. Thereafter, the panel has been locked. The main meter, the electricity is still been provided to the main meter, but the respective sub-meters of those 6 shops, it has been disconnected. And the APDCL yesterday, my lord, has expressed the inability.
So your landlord has done that?
No, not my landlord, my lord.
Who has done it?
My eldest brother-in-law.
So we are not filing a suit.
No, my lord. In fact, what has happened is the APDCL we have written to the police authorities also for the interference and involvement, my lord, for the matter to be taken to its logical conclusion and electricity to be provided, my lord. Time is of the essence. The APDCL has confirmed that we cannot do it because the landlord, the eldest brother-in-law, has threatened them. So we need your lordship's interference with just an order enabling the APDCL authority that there is no bar in law to provide the connection, subject to other considerations, my lord. There are 6 shops, my lord, who have been incurring heavy losses since 24th of July, my lord.
We'll have it on Monday.
Monday. Great,
Monday.
For motion item 1.
May I please, Lord? In this case, my lord, I have filed the additional affidavit today, my lord. It is not in record, my lord. The last occasion, my lord.
Counsel appearing on behalf of the petitioner submits that the additional affidavit has been filed today. List the matter after 1 week.
My lord. One Amron International company has been given the payment, my lord. That's what I pleaded in the additional affidavit.
We'll see when the...
My lord, I'm deeply obliged.
Item 2.
May I please your lordship? Is it the his authentication impugn order is starts from page 55. The relevant portion is starts from page 55, my lordship. The relevant portion page 57. Non-payment of contractual bill, my lord.
Two weeks. How will these people fix? Invasion, when did you inform the authorities?
My lordship at page 59.
Now, what is your allegation?
The allegation is that, my lordship, while filing the writ petition, we have made the chairman Bipuria Municipal Board as party along with the other respondents. The other respondents have filed their affidavit stating that the bills are ready. The chairman Bipuria Municipal Board, she has not signed on over the bill. Once she signs over the bill, everything will be dispersed. This was the affidavit filed. The respondent chairman Bipuria Municipal Board, after receiving the notice, also did not appear before this honorable court. Thereafter, getting this order of the honorable court, we have submitted the order, but till date the bill has not been released by the chairman Bipuria Municipal.
Is it your allegation that he has not given the approval?
Yes.
only on the aspect that he has not given the approval.
Approval.
Where is your statement?
Yes.
made?
Yes. I have annexed the affidavit filed by the executive officer at Annexa 6, my lordship.
No,
In the repeat.
where is your allegation that the chairman has not granted the approval? He may have granted the approval.
No, my lordship, the chief executive,
Where is your statement?
my lordship. Mm. Uh, my lord, Annexa, para 5, page 6. Even my lordship, I have done RTI also, I have that submitted in para 4 also.
No, I am asking,
Eh,
where is your allegation
Yes, my
that
lordship.
he has not granted the approval? Because
Yes,
the
my-
approval has to be given.
Certificate, my lordship, page 5. Page 5.
No, this is prior to this. I'm asking you after the judgment,
After
you
the
have
judge-
given on 31/5.
yes.
Thereafter, where is the statement?
Page 7, it starts from page 7. Page 7, last third, may I read my lordship? Page 7. NSS, the order dated 26/5/2025, passed in WPC number dash was served on 30/5/2025, respondent container, but till date, no compliance of the order dated 26/5/2025, passed in WPC number 224/2025 is done.
But where is your allegation? That you see, what was the direction?
Uh,
The chairman will give the approval and thereupon the payment would be made. Now you are before this court that you have not got the payment.
yes.
Now payment is to be made by somebody else. Payment
Both, chairman only, approval plus payment, my lordship.
that take all necessary steps for grant of approval for the payment of admitter and in any case within the outer limit of the after such approval of year, therefore said dues to the petitioner, release the year to the. But you have to be very clear because there was a direction for approval.
My lordship.
Payment will be made by the chief executive officer.
Yes, my
Isn't
lordship.
it?
Yes, but my lordship, I have stated.
Who will be making the
court
payment?
has given direction to the chairman only by the order itself.
No, the court has only directed the chairman for granting the approval.
Yes,
But the payment is being made by whom? There is no direction.
there is no direction.
But your case is that you have not received the amount.
Amount.
But where is your allegation that he has not granted the approval?
My lordship, I have
It's not
written-
there.
Yes, my lordship, I have written in this way, as the order dated this, compliance. is
That I have
not-
looked into it. But where is your allegation that he has not granted the approval? Because of that, you have not got. Because if you see the affidavit which was filed,
Para 8, my lordship. Para 8, may I read? That the petitioner respectfully states that because of the work of the petitioners mobilize his capital so that the petitioner on time can finish the allotted work. While the petitioner could not liquidate the outstanding.
no, there is no.
My lordship, last.
Again, you are saying the payment is to be made by whom?
I have them because of the non-payment of the petitioner's pending bills amount by the respondent oblique court till date, and as such the petitioner is facing acute financial difficulty.
Where is the direction passed by this court that he has to pay?
The approval.
Kindly see the affidavit,
Yes,
page 63. Paragraph 8.
my lordship.
Read the last. The remaining bill of rupees 5 lakh will be paid within next few days subject to the condition of approval of the chairman. Now there is a direction to the chairman to grant the approval
My lordship.
and thereupon to pay. There is no direction to who should pay.
My lordship.
But there is a direction to the chairman to grant the approval. Now
Approval
the approval has not been granted.
not granted.
Where is your allegation?
My lordship, in.
You file an additional affidavit.
My lord,
Ms. S.G. Burwa, the learned counsel appearing on behalf of the petitioner, submits that she would like to file an affidavit, additional affidavit. List the matter after 1 minute.
oblige, my lord.
3,
My lord. Now the grievance of the petitioner is that, my lord, her name has been marked as D voter since 97, page 46, your lordship. And after my lord, so many years, no effort has been made to refer the same to concern SP and thereafter my lord to the tribunal, my lord.
Where is my orders? I passed similar order. You have it? Have you put the LAC number? And the voters list? LAC number and which is the SP? Bhawanipur constituency, SP voter Bozali.
The copy give, huh? Well, item 5 is same. my lord.
Five also same.
Same.
Five.
Four. Oblige you.
May I please, your lordship? A matter may be passed for time being, your lordship. My senior is on late.
What is your case about? You can type it right. Type it right. Yes, Mr.
My lord, although my lord, our name has been shown, copy has not been served on us. My lord, we have inquired with, there is a signature, my lord, but then I have inquired, nobody has received it, my lord.
Mr. M.K. Chaudhary, the learned senior counsel, hearing state by so and so,
I am Sharma.
submits that although the name have been shown in the cause list,
Yes, my lord. As
but
we have received it.
no copy of the writ petition has been served upon the standing council of the IOC. So taking into account the above, list this matter on 6th of August. In the meantime, the counsel for the petitioner shall serve a copy of the writ petition upon Mr.
Okay.
M. Sharma assisting Mr.
Date is wrong, my lord.
Huh?
Your lordship says 6th of August. my
Oh, Aji ki date?
Yeah.
Ade. On 13th of August.
Item 6,
E-voter, huh?
Lordship, the petitioner.
D-voter, okay. Dispose. Give the reference, those details.
Yes.
Border, which SP border,
Yes,
which
Lord.
one, LAC?
item 7,
Here,
D-voter,
yes, 2005, 43 nang Borford Island. In 2005, 43 nang Borford Island.
huh?
The voter list of 2005, 43 nang Borford Island.
Give the name. This side.
item 8,
My lord, on 1st of July, a raid was conducted by the police personnel of Hoiberg Police Outpost, my lord, in the hotel of the petitioner, and the hotel was searched, my lord, and 564 gram of beef, my lord, was allegedly found, my lord. So accordingly, my lord, one FIR was registered. The younger brother of the petitioner was taken into custody, and key, my lord, hotel was sealed and key was taken away by the police, my lord. Now, my lord, after filing of this writ petition, my lord, now, my lord,
Yes, we are appearing for the government.
no, my lord, some development took place, my lord. After filing of this writ petition, already, my lord, deputy commissioner called the petitioner and handed over the key, my lord. So since the petitioner is allowed to run the hotel, now, my lord, this writ petition has become infractious, my lord.
Counsel appearing on behalf of the petitioner, Mr.
M.A. Islam, my lord.
M.A. Islam submits that the instant writ petition has become infructuous in view of the fact that the keys to the hotel have been handed over and the petitioner is presently running the hotel
Running the
in Kochi. Accordingly, the instant petition stands closed.
Okay. खाली हो रहा है.
9,
Your Lordship, our case, item number 6, Lordship, our case,
Item number?
item number 6. So kindly matter may be time being Lordship.
Which item number 6?
Item number 6, Lordship, the voter Lordship matter,
Disposed of.
but I don't know.
Let me dispose of it. You see that the order which is being passed is, if there is no reference, then the reference will be made by the SP border.
Lordship, some things, something are there, Lordship, in our case, Lordship. So my signature will appear just for time being, Lordship.
Why?
Lordship, I have a look.
You want something more? That this
Lordship,
court should say that you are not, you should
Lordship,
not be.
petitioner name, the petitioner number 1 name is, their name is, in 1966, their name is enlisted Lordship, petition number 1. And petitioner number 2 also is a government employee. And they are, have a look, page number.
Madam, the question is, this court is not in a position to decide as to whether your name has been marked rightly or wrongly as the voter. It has to be only decided by the foreigners tribunal.
Yes.
The question is, if you have been referred, no question of reference. Earlier reference, if it is made, it will be informed to you. If it is not, then they will refer. But they cannot continue to keep you as the voter. That is the order. They will make a reference. The reference can only be decided by the
Tribunal.
foreigners. So now get ready, ask your senior to get ready to do the matter before court number 2, who will be taking the foreigners tribunal if it is decided against you in the tribunal. Okay. Now what is this item? Item number 9.
item 9,
Mr. Ghosh, what is this?
My lord, for load security, enhancement of load security, I have sanction also, I have paid also. Others has been provided, but I was not provided with load. security.
What?
Kindly see page 11, my lord.
You are not being provided with the electricity connection.
10 kilowatt. Enhancement of load security.
You
Load,
want how much? What is your
10 kilowatt,
what is your present load?
3 kilowatt,
6.
3,
You want to make it 13,
10,
10.
10.
That has not been allowed.
Allowed.
Then
Allowed, payment has been made. Only physically they are not providing.
physical?
That means on actual basis, they are not providing three-phase connection.
I
In
don't
spite of their, my lord, earlier below 5 kilowatt, single phase. Above 5 kilowatt, there will be 3-phase. I applied for 3-phase with load security 10 kilowatts. That was sanctioned.
The sanction is granted, but the 3-phase meter has not been given to you.
Yes.
That's your case.
That
Yesterday we have already granted, madam. I have my instructions.
I have no interest.
See?
Next week, I'll take instruction. my lord.
We finish it now. The consumer has applied for a 3-phase connection, but only single-phase LT meter was available near his premises from the nearby area. Although 3-phase LT was available from another DTR, consumer insisted take the power from the other DTR where voltage profile is better. Therefore, power was provided to him temporarily via the single-phase LT as he needed the power on other. Since then, the phase augmenter was in process, and finally today on 7/8, single-phase was augmented to 3-phase network, and the power is being fed to his premises by the 3-phase connection from approximately 4:30 p.m. And I hope heard Mr. S.K. Ghosh, the learned counsel, appearing on behalf of the petitioner. Mr.
Bidas, my lord. Bidas.
Vidas appears on behalf of the APDCL. The case of the petitioner herein is that the petitioner initially had a single phase connection of 3 kilowatt. The petitioner sought for enhancement of the load to 10 kilowatt, which was duly sanctioned by the respondent authorities. The petitioner also made the requisite payment for enhancement of the connected load.
On
The
19
grievance of the petitioner for which the petitioner approached this court is that in spite of the sanctioning of the 10 kilowatt, which is required to be provided with a three-phase connection, three-phase meter. The three-phase meter have not been installed, for which the petitioner had approached this court. Mr. Bidas, appearing on behalf of the APDCL, submitted on instructions that on 7/8/2025 at 4:30 p.m., the three-phase connection to the petitioner's premises have already been installed. And in that regard, have also produced an instruction including the photographs of the three-phase connection installed to the petitioner's premises. The said document is kept on record and marked with the letter X. Taking into account the instructions so provided, as well as the document which is kept on record and marked with the letter X, nothing further survives in the instant writ petition, for which the writ petition stands closed.
much.
Item 10,
Yes, madam, what is it?
Your lordship. The petitioner as contractor had.
Non-payment.
Non-payment of
The works of 2010, 2012, 2012,
12 and 12.
all 2012.
Huh?
Have to
These
take
are
it.
admitted, however,
No.
Yes.
I cannot.
page 21.
No, Sujit. Wait.
Now tell me, madam, how is it possible
Lordship.
that they will find out or verify? If you are approaching this court after 10 years or submitting a representation after 10 years,
The lordship here addressed the representation.
so representation, does it enhance extend the limitation? One fine morning you think that, okay, look here, this is a case, I have to get some money In respect thereto, the petitioner have received certain amounts. However, there was certain balance amount for which the petitioner had submitted representations from time to time. It is noticed that on 27/5/2022, the executive engineer, PHE, Hosai Division, had written a letter to the chief engineer, PHE, stating inter alia that there is a certain dues which is payable to the petitioner. The said aspect can be seen from the communication dated 27/5/2022. So taking into account the amount, the respondents are directed to bring on record their stand by filing their affidavits on or before 27th of October 2025, given to the petitioner to file reply thereupon on or before the next.
Item 11,
May I appeal your lordship? Lordship, matter relates to non-payment of higher service bill, lordship.
Period.
Lordship. Period, lordship, 2021 to 23, lordship.
Where is your, how much amount?
Amount is, lordship, 7,24,488.
Where is your work order?
Requisition order, your lordship will find the annexure 2 series, lordship.
Next, sir.
Requisition order of the vehicle, lord.
Order requisition made. This is for the year 2021.
2020, some of the copies have been sent, lordship.
Huh?
Some of the,
Oh, wow. Then why should I look into the other copy?
this is annexure 2, lordship.
Where is your bill?
Bill, lordship, of annexure 4, lordship.
Huh?
Annexure 4 series, lord. They have received in the 2020, which. Annexure 4, from page 26, lord.
How much amount
Bill,
entitled?
total amount is, lordship, 7,24,488.
Police. Who
Police.
has done it? Police.
Commissioner of
Issue notice making it returnable on 10th of November 2025. Mr.
State.
Collier, the Learned Council accepts notice on behalf of the respondent number
All the respondents.
5. Extra copies be served upon him within 3 days. The case of the petitioner herein is that the petitioner is a owner of a Maruti Gypsy vehicle bearing registration number AS01DH2875. The respondents have taken the vehicle on hire on various dates, as would be seen from the enclosure to the communication dated, as would be seen from the enclosure to Annexure 5 to the writ petition. It is the case of the petitioner that the petitioner is entitled to the amount of rupees 7,24,488. And as the said amounts have not been paid, the petitioner has approached this court by filing the writ petition. The respondents are directed to bring on record their stand by filing the affidavits by 31st of October 2025. Petitioner given the liberty to file reply if so advised on or before the next day.
12,
Item 18 is also similar.
What?
Item 18 is also similar. Amount is dependent.
We will look when 18 comes,
Okay.
not prior to that.
item 12,
This matter related to the settlement of the Rukuya by Agri market. That is by in the district of Baksha. And by the petitioner.
Settlement of
By Agri market. Rukuya,
it has been given to the respondent number 6.
Agri market, my lord. He is the petitioner, he is the highest bidder.
You are the highest bidder. You are the highest bidder.
Yes, petitioner is the highest bidder.
Who are you?
My lord, I am appealing
When they page,
our respondent
thirty-
number
page
2, 3
37,
and 5.
Respondent number?
page 37, my lord.
Just 1 minute, Mr. Sharma. 3 and 5. So you are the main problem. Now, the thing is, you are for BTC
Yes, my lord, on behalf of SR,
on behalf of,
SR government.
who is he? He,
Standing Council of
He's
BTC.
the block development officer?
SR is Standing Council of BTC.
Oh, so none appears for the BTC. Don't worry.
I am appealing on his instruction, my lord.
Yes, you are challenging what? Page 37.
Yes, page 37, my lord.
Read
comparative
through.
statement.
You have made 99,500. It is being given to whom? The respondent number 6, Pon Diamiri, at 74,800.
It's the second bidder.
Although these people have the block development officer approved number 1, but it is being given.
Settlement was given to me by order letter 36, annexure,
Sujit Baru
annexure 4.
being the highest bidder. Who is Sujit Baru? You. Is allotted temporarily to Iman being the highest bidder to enter in favor of the principal secretary. That is 38. Expert order dated to enter in favor of Iman. Oh? What is this type of things going on? Yesterday also I set aside this time. I think this must have been done by the principal secretary who must have called you up.
My lord, notice maybe is
What notice? Notice to notice. I think this is a case for setting aside. Call Mr. S. Bora. Who is there? S. Bora or a person who is in charge of BTC. Not you.
yes, my lord.
We'll set aside this immediately. Because if I issue a notice, I have to stay this. You are going to lose out. Get hold of a proper counsel, not you.
Yes, ma'am.
Get hold of Mr. S. Bora, not your SI Roman. He is of no help. Mr. Sharma, I'll dispose it of right away. Set aside this type of thing doing.
13,
Yes, what is this?
Cancellation of porter license. Railway porter license. It was in the year 2019. He was convicted.
Oh, he was convicted, guilty
Yes.
plea. That day I was taking a similar matter, na?
But,
Were you there?
no,
Yes, there was a similar matter where this person had pleaded guilty
yes,
and he was convicted.
yes,
So in terms with a particular rule you have,
yes, sir.
and some
Conviction.
clause, I think Roman 2 or something.
Yes,
I
sir.
forgot.
11A, sub-rule 7 of the joint accounts of commercial circular return.
So there, as per that, you have done it.
Yes.
Hello, he's not here. What to do? None appears on behalf of the petitioner when the matter is called up. This is the matter after 1 week. Mr. Bora, this is also a typical case which I disposed of yesterday. Here, what has happened as it appears, some market or something. The petitioner had quoted 94,000 something. The respondent number 6 quoted 77,000 as it appears. The block development officer, who is the number 5, he had said that the petitioner should get it, and in fact temporarily granted him. Then the principal secretary calls up and says, no, give it to him, and accordingly it's being given. I can very well issue a notice and stay it, but the fact is you are going to lose at the end of the day. So instead of that, I set aside this because this is without any reasons. You take a call whatever may be required. But otherwise, from the comparative statement which is appeared, the petitioner is otherwise technically eligible. And he has quoted everything. So if I stay, it is your loss. Because you have to later on, you can't get the money this way or that way. Heard Mr. K. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. S. Bora appears on behalf of the respondent number 2, 3, and 5. Ms. So-and-so appears on behalf of the respondent number 1, and Mr. Bokolia appears on behalf of the respondent number 4. None has a full stop. This court has taken up, taking into account the issue involved. This court dispenses with an order which this court proposes to pass. This court dispenses with the service upon the respondent number 6. It appears from the materials on record that a notice inviting tender dated 7/5/2025 was issued by the block development officer, that is the respondent number 5 herein, for settlement of market, markets, bohats, parkings, parghats, ferries, cattle ports, ponds, etc. for the year 2025-26. The petitioner, along with various other bidders, participated in the market pertaining to market, namely number 1 Rupohi Hat. Full stop. It appears from the comparative statement which have been enclosed as Annexure 3 to the petition that the petitioner as well as the respondent number 6 were the successful bidder, were the eligible bidders, and the petitioner quoted 99,500, whereas the respondent number 6 quoted 74,800. In pursuance, in the said comparative statement, while making the said assessment, the respondent number 5 had approved the bid of the petitioner. Subsequent thereto, on 30/6/2025, taking into account that the petitioner was the highest bidder, the petitioner was temporarily allotted the number 1 Rupohi Hat Bazar for collection of tolls with effect from 1/7/2025 to 30/6/2026. Subsequent thereto, it is seen that by an order dated 5/7/2025, the respondent number 5 allotted the number 1 Rupohi Hat Bazar in favor of the respondent number 6, who admittedly had quoted a lesser amount to that of the petitioner. That too without assigning any reasons. Taking into account the materials on record, this court, and more particularly the comparative statement so prepared by the respondent number 5 and the order dated 30/6/2025, this court is of the opinion that the order dated 5/7/2025 cannot be sustained as the same do not disclose any reasons as to why the petitioner order dated, why the order dated 36/2025 was nullified by the order dated 5/7/2025. The action on the part of the respondent number 5 to pass the order dated 5/7/2025 being without any reasons. This court therefore sets aside the order dated 5/7/2025. So accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The order dated 5/7/2025 is set aside and quashed on the ground that the same is unreasonable and unfair and violative of Article 14 of the Constitution. This court directs the respondent number 5 to pass appropriate orders taking into account the tender conditions as well as the comparative statements so prepared and grant and for settlement of the number 1 Rupohi Hat Bazaar.
Item 14.
Oh, Technico, alone comes now. Good. Now come up. Let us hear on merits. What is your case?
Yes, my lord. What has happened in this particular case? I am the distributor
Ah.
for distribution of LPG cylinders under the IOC matter. And in this particular case, earlier the notice was issued that your notice will find at page 38.
Page
38. This notice was issued on 13/2/2025. Now, my lord, I am reading the third paragraph. Recently, a review of the credit debit path to the distributors, transporters on account of market error cylinders in the year of 2023-24 was carried out from North Guwahati BP. The review has revealed that the credit has been passed to your PAD account, that is pre-audited account, debit account. For the empty cylinders returned to the plant which is equivalent to the empty oil amounting to 12,62,836. The said credit was incorrectly passed on to your account since the ERV slips were not signed, that the equipment return vouchers either by the transport or distributor or both, which is in violation of specific policy. It may further be noted that no not followed. The aforementioned procedure is a violation of clause 30.
Okay. So now this is a show cause notice.
This was the so-called notice.
Then you
against
replied.
Yes.
At page 39.
Not reply as well as my lord, I came before this honorable court telling the validity of this so-called notice, my lord. That older your lordship will find at page 2051. I stored the time, my lord.
Then where's your reply?
Now, my lord, what has happened in this process? I came before this honorable court challenging the validity of this.
Oh, on the documents not being provided.
Yes.
So
Now,
your case is this notice was asked, but what is the documents you are asking?
asking, my lord, your lordship, see, those are the at page your lordship will see at ERV sleep, my lord, at page 61, my lord.
Page
61, my lord. These documents I saw. Page 61, annexure F.
So you want only the ERB slip,
Yes,
nothing more.
nothing more.
You have it?
My lord, my instruction is that, my lord, they were called because, my lord, this is very voluminous. They were called for personal hearing and, my lord, to see the ERVs. They did not come. Now, but further instruction is that, my lord, if your lordship gives 7 days time, my lord, up to 15th of August, will be, my lord, supplying them the ERVs.
You'll be supplying the ERB much.
Yes.
Then you supply your reply.
Yes. And in the meantime, my lord, the order, the impugned order dated 29/7 to 25 may kindly be till then.
Why?
Because they are going to deduct the amount. If they deduct the amount
Impugn order, which order?
at page, your lordship is 64. The last line, my lord.
Yes.
We are going ahead with the debit deduct.
Heard Mr. O.P. Bhatti, we dispose it of. Heard Mr. O.P. Bhatti, the learned counsel appearing on behalf of the petitioner. Mr. M.K. Chaudhary, the learned counsel appears on behalf of senior counsel, who is also the standing counsel of the Indian Oil Corporation. Appears on behalf of the respondent numbers 1 to 5. Mr. M. Sharma, who assists Mr. M.K. Chaudhary, the learned senior counsel, accepts notice on behalf of the respondent number 1-5. Oh no, it appears on Mr. M.K. Chaudhary, the learned senior counsel, assisted by Mr. So-and-so, appears on behalf of the respondent numbers 1 to 5. So, taking into account the issue which is involved in the instant proceedings, this court takes up the instant writ petition for disposal at the motion stage. The admitted facts, as would be available from the materials on record, would show that the petitioner is a distributor.
Yes.
Distributor of
LPG.
LPG cylinders of the respondent corporation. On 13/2/2025, a notice was issued to the petitioner alleging violation of clause 23 small a of the Indian to without Indian bracket liquefied petroleum gas bracket close distributorship bracket domestic and commercial bracket close agreement, and it was further alleged that an amount of rupees 12,62,833 was incorrectly given credit to the petitioner. Under such circumstances, by the communication dated 13/2/2025, the petitioner was asked to show cause. The petitioner, on receipt of the said communication, submitted a communication after receiving the said show cause notice dated 13/2/2025, submitted a communication to the DGM plant, North Guwahati LPG bottling plant, dated 18/2/2025, stating inter alia that the petitioner would submit a detailed reply, that the petitioner would not be in a position to submit an effective reply unless the documents on the basis of which the said show cause notice was made is provided to the petitioner. During the course of the hearing today, this court inquired with Mr. O.P. Bhatti, the learned counsel, as to what are the documents which have been mentioned, which the petitioner seeks for the purpose of submitting an effective reply. The learned counsel submitted that the documents which are required are the
Equipment return vouchers.
ERV slips.
Yes. Full form.
What is the full form?
Equipment return vouchers.
Bracket equipment return voucher, which was made the basis for issuance of the show cause reply, for the show cause notice. This court have also taken note of the order passed by the coordinate bench of this court dated 17/3/2025 in WPC number 1469/2025, wherein this court observed that the respondent authorities should supply any document that the petitioner may ask so as to enable them to submit their respective reply. It is further taken note of that pursuant to the said order dated 17/3/2025 passed in WPC number 1469/2025, the petitioner submitted a communication on 28/3/2025 seeking the ERV slips. However, without furnishing the ERV slips, the respondent authorities have issued the communication, the email dated 29/7/2025, whereby the petitioners whereby the procedure for making debit/deduction from the entitlement of the petitioner, whereby it was informed that the procedure for debit/deduction from the entitlement of the petitioner would be taken up. It is under such circumstances that the communication dated 29/7/2025 have been assailed before this court. Mr. M.K. Chaudhary, the learned standing counsel appearing on behalf of the Indian Oil Corporation, submitted that the ERVs in question, are voluminous in nature, and as such, the respondent corporation had requested the petitioners to inspect those documents in their office.
Yes, my lord.
However, the respondents are not adverse to providing copies to the petitioners, subject to the condition that the respondents appear before the whom?
My lord, it will be
Respondent number 3, my lord.
3.
Manage
Respondent number
3.
3
Manage.
for accepting the copies of the ERV.
Right.
The learned senior counsel further submitted that as per his instructions, the copies can be provided of the ERVs, the concerned ERVs can be provided to the
Copies, my lord.
petitioner.
Copies, my lord.
Copies,
my lord.
copies of the concerned ERVs can be provided to the petitioner within 7 days from today.
Right.
Full stop. Taking into account the said submission and the subject matter involved, this court therefore disposes of the instant writ petition with the following observations and directions. The representative of the petitioner shall appear before the respondent number 3 on today আজি হল 8 তাৰিখ নি 8 তাৰিখ না on 18th of August on 18th of August at 10:30 a.m.
My lord.
Full stop. Before the respondent number 3. The respondent number 3 shall provide the ERVs on the basis of which the respondent corporation have issued the show cause notice dated 13/2/2025. Number 2. The petitioner immediately thereafter, and the petitioner is directed, and the petitioner is given the liberty to submit the reply within, how much time did you give earlier?
That is 1 month. Earlier 1 month I was given.
30
Not
days.
1 month, now no more 1 month, now you know. By 29th of August 2025. Full stop.
Let it be 15 days, my
It is already 15 days.
done it. All right.
Okay, on 3rd of September 2025. On or before 3rd of September 2025. Full stop. The respondent number 3. The respondent corporation, based upon the respondent corporation shall pass appropriate orders based upon the said proceeding, shall pass appropriate orders on the base duly taking into consideration the so-called replies so submitted, if so submitted by the petitioner. Thereupon, full stop. Number 5, till such decision is passed, the decision is taken, comma, the email, the decision, the direct, the email, the contents of the email dated 29, no, the respondent authorities shall not proceed with debit or deduction from the entitlement of the petitioner.
The next one is same. I don't know.
Item 15.
Is same.
Them,
Only the orders will be different.
is it same with that?
My lord.
Order.
Order will be same, my lord, only the page numbers are different. my lord.
Now, where is the show cause notice? 18/2.
That
It
is
it is 18/2, annexure
Yeah.
B. Now let us see whether it is same or not. Whether you
that
have
your lordship will
earlier
find
where you were there, Sudipta. Where is
Page,
it? Number 2. Then this order is
Page
passed on
54.
4/4/2025. Then when
Page
did you give
54.
it? 7/4.
It is
7/4 হ'ব যোনটো আপোনাৰ এনেক্সাৰ এফৰ কথা কৈছো এইটো 7/4 হ'ব আগতে বেলেগ ডেট এটা আছে এইটো এনেক্সাৰ আৰু ইয়াৰ ডিসিশন ইজ ইমেইল ডেটেড
page 54.
37.
Madam.
Item 16.
Yes.
May I, Priya Lordship? Lordship, we are challenging the order passed by the respondent corporation whereby my security money was forfeited. I was debarred for 2 years and risk and cost was imposed upon me.
Huh?
My security money was forfeited. I was debarred for a period of 2 years and also risk and cost was imposed upon me.
They have gone for a notice inviting tender.
Lordship, I participated in a notice inviting tender. I was issued the LOA. Now the terms of the tender say that after receiving the LOA, that after issuance of the LOA, within 15 days, I am to deposit a security deposit. Lordship, the LOA was issued on 30/8/24.
30?
30/8/24. And as per our calculation, the period ended on 19/9/2024.
38.
18/9/2024.
38.
30/8/2024. And 15 days expires on 18/9/2024.
Why?
Because 15 working days, Lordship.
It's written 15 working days.
Yes, Lordship.
Where
15
is it?
working
LOA?
days. Yes, Lordship. What is that? Lordship will turn to page 56.
Lordship, these are the security deposit which I have to give.
Shall furnish within 15 working
Yes.
days of the acceptance.
This
Okay,
is in
then-
relation to clause number 1. Sub clause number 1.
Then
So Lordship, on 18/9, which according to us is the last date, they send us an email saying that you have to deposit your money by 19/9.
19/9. Okay,
19/9, I could not deposit.
Then?
I deposited on 28th. Lordship, what I'm on is, Lordship,
Hmm.
when the last date was 18/9,
Hmm.
by their conduct, they've given an extension of 1 day and brought it to 19/9.
Hmm.
So Lordship, that criteria of 15 days does not become mandatory, it becomes a directory clause. And there was a delay of only 1 day. Even going by their calculation, they say that the last date is on 19. I deposited on 20th.
oh, somebody doing something good to you has become more disastrous to them.
Yes, Lordship, it has become disastrous to me now, Lordship.
Why?
Because they are saying that your last date expires on 18/9. So since the order was communicated to you on 8/30.
Now what are you challenging?
Lordship, I am challenging the order by which my security deposit has been forfeited.
Very well.
I was debarred for 2 years by the same order and risk and cost was imposed upon me.
Risk and cost imposed.
And Lordship, the entire security money which I had deposited has been forfeited. There is no quantification of any law for deposit of for forfeiting
Now,
the entire.
to me, if it is not deposited, the risk and cost will be imposed.
Lordship, that is.
Where?
Page 57, Lordship.
Yeah, no, page 57. In the event
Yes.
of a failure to remand.
In the event,
to
clause
furnish
at
the
Lordship, in the
requisite
event of
amount
failure.
Clause 1A by the due date, security deposit in the form of bank guarantee and the year including extension of the contract shall be summarily exercised for future of the fund, and the corporation shall proceed to appointment of it. Any losses or damages arising out of and incurred by the corporation by such conduct of the year will be recovered from the contractor without prejudice to any other rights and remedies. The contractor will be. So the clause is there.
The clause is there, Lordship.
Then
But
what is
the
wrong?
entire security money which I have deposited, the entire money has been forfeited, Lordship.
Very good. What? You don't have a case.
My lord, this is a second round of litigation, my lord. Earlier, the honorable court's order is at page 142. The writ petition was dismissed because they have approached the GRC. Now, GRC has rejected their prayer,
The Grievance Redressal Committee.
which is at page 157, my lord.
Oh, this aspect has been already decided.
Yes, my lord. And
No, it
the
Thus,
GRC
the
order is
petitioner
dated
could have
14/11/2024.
given an extension for a period of year for submission of bank guarantee in terms of a year. The fact remains the petitioner has not even submitted the request regarding within the month. And this was a primary view that there is no merit in it. However, in view of the fact that the petitioner has filed a representation before the demand, accordingly, this court is dismissed. Having regard to the alternative remedy has been given.
We have availed the alternative remedy, Lordship.
That
The
has
or-
been dismissed.
That has been also rejected. Our case
That
has
is
been.
why you are before this.
That's
Yes.
why we are before you, Lordship. Lordship, at this stage, a notice may be issued, Lordship, only that much.
Notice may be issued, ma'am.
Notice.
Yes, ma'am.
Only notice.
Only.
Issue notice. That I am issuing notice because of him,
I'm
not
deeply obliged,
because of
Lordship.
you.
I'm deeply obliged, Lordship.
Nowadays, FCI is having less matters because of that. I'm taking consideration of your colleague. So why are you making the grievance redressal committee a party unnecessary?
Because their order is under challenge, Lordship. The order passed by the Grievance Redressal Committee is under challenge.
Issue notice making it returnable on 10th of November 2025. Steps be taken by Mr. So-and-so, BK Singh accepts notice on behalf of the respondent number 1 to 6. Extra copies of the petition be served upon them during the course of the day. Within 2 days. The case of the petitioner herein is that the petitioner was
The LO is at
LOA.
Lordship 393.
the successful tenderer in respect to a notice inviting tender
Dated 6/6/2024.
dated 6/6/2024, issued by the respondent corporation. In terms with clause Roman 9A of the Annexure Roman 1 of the notice inviting tender, the petitioner being a successful tenderer was required to deposit the security deposit was required to furnish the security deposit within 15 working days of acceptance of the tender. The counsel appearing on behalf of the petitioner submits that as the petitioner was intimated that the petitioner is the successful tenderer on 30/8/2024, and the 15 working days would be would fall on 18/9/2024. However, the petitioner did not submit. The petitioner could not submit the security deposit within the said period. Be that as it may, the respondent corporation granted a further opportunity to the petitioner to submit the security deposit by 19/9/2024. The petitioner, however, submitted the security deposit on 29/2024. The learned counsel appearing on behalf of the petitioner submitted that as the respondent authorities have extended on their own volition the period from 18/9 to 19/9, the condition which is mentioned in clause 9A of Annexure Roman 1 to the notice inviting tender has to be taken as a directory condition. And time was never the essence of the contract. He therefore submitted that as time was not the essence of the contract, the respondent authority, having accepted the security deposit on 29/2024, the respondent authorities could not have taken recourse to clause F of subclause F of clause Roman 9 of Annexure Roman 1 to the notice inviting tender. He, however, he submitted that the respondent authorities have not only forfeited the security deposit, but also have issued a fresh notice inviting tender at the risk and cost of the petitioner, and as well as imposed a ban of 2 years. It is under such circumstances the petitioner has approached this court, challenging the said actions on the part of the respondent corporation. Mr. P.K. Singh, appearing on behalf of the petitioner respondent corporation, submitted that this is the second round of litigation, inasmuch as the petitioner earlier approached this court, and this court, taking into account that there was an alternative remedy available by an order dated 8/11/2024 in WPC number 5776/2024, granted the liberty to the petitioner to approach the respondent number 6. The learned counsel for the respondent corporation further submitted that a question of exercising the writ in the nature of certiorari do not arise, taking into account that there is that the decision so taken by the respondent number 6 is in consonance with the contractual terms. So be that as it may, this court Taking into account the said submissions, this court fixes this matter, directs the matter to be listed on the date, on the returnable date. In the meantime, the respondent corporation shall file their affidavit by 29th of October 2025. Liberty is given to the petitioner to file the reply on or before the next date. The decision, any decision taken in the this court observes that the decision so taken by the impugned in the instant proceeding shall be subject to the outcome of the
Obliged lordship.
Item 17.
Yes.
My lord, an NIT was issued by the Milord Indian Oil Corporation. Now, if your lordship would kindly come to page 43, Milord. This is 51A, page 43. Condition governing the offer of tracts.
Yes.
Such bidders shall quote at least one own tract as on the closing date of the tender. Milord, the closing date of the tender was, Milord,
You are referring to which
12/5/25.
one?
Yes,
Clause?
clause, Milord, 51A at page 43.
Yes, such bidders
Shall quote at least one own tract. That means he must be owner of the tract
closing.
as on the closing date of the tender. So, Milord, going by this original stipulation, Milord, both the petitioners were not eligible. However, they issued a corrigendum. By virtue of the corrigendum, we became eligible. Please come to page 151, Milord.
Yes.
As a matter of fact, at page 152, 152, right-hand side top.
Yes.
In case of TTs operating in existing contract, whose ownership cannot be transferred during the pendency of the running contract, and hence the formalities for transfer or ownership could not be completed as on the due date of the new tender, such vehicle can be sold through an agreement to sale, that is ATS, and both the seller and purchaser shall have to submit an affidavit as per the attached annexure page annexure 40 and 41, along with the valid registration document and the PESO is, Milord, that explosive study license in the name of the seller. Now, this is very important. Such tracts shall be considered as own tract of the bidder for bid qualification and allocation purpose. And this, my lord, if I am having an agreement to sell also with a person who is having an existing contract, and I submit the affidavit in annexure 40 and 41.
Affidavit of owner and the purchaser.
Vendor and the
Both
vendor
are
and the
given,
bidder.
then it can be
Yes,
done.
yes.
Yes.
Now, my lord, they have totally misconstrued this, my lord. They said now at page number 79, my lord. Sorry, 197.
Yes.
This is the impugned order. You are informed that your bid for the above tender has been rejected during technical evaluation by the duly constituted committee for the reason minimum one own TT not offered.
Then you must have written for clarification.
Yes.
Then what happened?
Then also they have not done anything, my lord.
If they written
Yes.
origin.
Representation is there, my lord.
Now your representation, I've seen it.
Ah.
You failed to submit the below mentioned document
Uh-huh.
at page 204. Please submit the documents as listed below within the due date as mentioned in the year. This is given to whom? Page 102, 204.
My lord.
What is your name? You are different.
This is, my lord, another bidder.
Other bidder, yes.
Urban Tech Enter.
In this case, my lord, they have bestowed this, favor. In our case, it was not. So, my lord, it's a clear case where they perhaps misconstrued the whole thing, my lord.
Yes, Mr. Borua, what is this?
My lord, the
The explanation which I was, instruction which was given is that they have actually considered saying that the original tender condition says one own truck. So they have kept one own truck. Besides that, if any other trucks, then the ATS agreement would effectively come into play. That was the instruction.
But you see, that kindly come to page
152.
Kindly 151.
151 is.
Yes. Clause 5.
Yes.
The bidder should upload the attested copy of the RC book, all offered trucks to the capacity as defined in the IMAT, out of which the owner must
Bidder
own
must.
at least one truck in his name. If the bidder does not, if the bidder does not have the minimum one truck, then the bid of such bidder will not be considered. So this was the origin.
Origin.
Now what we find is that what is uploaded, the second portion,
Yes.
changes to the relevant clause. The bidder should upload the self-attested copy of the RC book of all offered own plus attached of the capacity as defined in the scope of the work done, out of which the bidder must own one truck at least. If the bidder does not have minimum one truck, then the bid of there will not be considered. So this remains. Then I think they have added this.
They have added this.
Now, what do you say about the second part? Such trucks shall be considered as own truck of the bidder for bid qualification and allocation purposes. Or you are saying, as per you, it says
Yes.
that this is in the other trucks
Yes.
which are to be submitted,
Yes.
where the details of which have been submitted during the pendency of the contract cannot be changed.
Yes.
And as such, you require evidence.
Yes.
And it will be treated as if it is being owned by the owner.
It is being owned by the owner.
So this is on in respect to the other trucks.
This is on
Not
respect
this.
to other-
This the original conditions still continue,
Still continues.
but
as-
this is a clarification as regards the other trucks. Otherwise, the other trucks they will be able to use.
Used. Yes.
That's your.
That is the.
We issue a notice,
Right.
file your reply,
I'll make it.
and then we expose it off.
Milord, the only thing is, Milord, these two trucks, Milord, they will not allot me in the mid-10.
Huh?
Two trucks, they will, at least
How
two
many
slots
trucks
could be,
they
kept.
are?
Two, Milord. One each.
One each.
No, how many trucks are there?
One each, Milord. Both the petitioners, one each.
This is bulk LPG by road for date of.
Now, we have offered one each, Milord. Both the petitioners offered one.
There are two.
There are two petitioners and two trucks. Because, Milord, I also can offer ATS also. As per the original terms, I can offer, if I offer one own, I can offer also another attached truck also. Now, by virtue of the corrigendum, Milord, even the attached truck would be considered or constituted as an own truck. That is the understanding which we get, Milord. Perhaps, Milord, may not be, I mean, bona fide. Bona fide also, Milord, some wrong and misunderstanding could have taken place. Otherwise, Milord, this subpara, such trucks shall be considered as own truck of the bidder for bid qualification and allocation.
Now, how many trucks do you require?
Well, again, that is an issue because these are ongoing contracts, tentative thousands
Because
of trucks. Yes.
Because
Milord, there is one more category, Milord, proposed
107.
truck. There is one more category proposed. I stand on a better footing than that. If your lordship would kindly come to page 44, Milord. Huh? No.
Yes.
No. Yes, page 42, Milord. C.
44.
C, Milord. At page 42.
Yes.
There is a third category. These trucks may not be available with the bidder as on the closing date of the tender. Bidder may give their intent in offering proposed truck in Annexure 22 or 23, which will only be considered by the corporation in case the NIT requirement is not fulfilled as per the tender evaluation criteria. At least I stand on a better footing than this, Milord. When this is also there.
Total, I think, my lord, there are 1,079 trucks. Total tentative figure is 1,079 trucks.
1079.
Yes, that is 10.
So you are asking therefore,
Some protection, my lord, in the event lordship finds there is merit in the writ petition, so that, my lord, my,
proposed trucks will come in when after getting everybody.
yes.
Then also you don't have 1079.
Then also we don't mean, no.
Then only the proposed trucks will.
Then only proposed trucks will come.
Otherwise, no.
Otherwise not.
So now the question is, as in view of the corrigendum which has been issued,
Yes.
whether there is a requirement of
Own truck.
having own truck is dispensed with, taking into account that if you have an ATS, then and it is being supported by affidavits of the purchaser and
An explosive license.
of the owner,
Right.
then it will be deemed to be a truck.
It will be deemed to be.
Owner. If it is a deem, by deeming you are doing it, so therefore would he come within the ambit? That is the short.
That is the
question.
short question. What is
Okay,
that?
let me come back. So I think that this is a process. You can wait for 2 trucks for some time.
Yes.
Huh? Let me come back. But why there are 2 persons, 1 petition?
Exactly same cause of action.
So everybody, then that particular person should be. It is not.
No, lordship, he has
Only
paid.
pass
the-
1 truck.
He has paid the.
No, then I'll do one thing, pass only 1 truck you do. Now both of you choose. I'm coming back, only 1 truck.
He 42 million. On top, bidder can offer attached truck in the ratio of own attached 1:1.
It's okay. Means
That
how
means
many
if I own
trucks?
4 trucks, if I own 4 trucks, own truck, then I can offer 4 attached.
No upper limit.
No upper limit.
No, minimum.
Minimum 1.
Minimum 1.
Minimum 1.
Yes.
Then I think this appears to be an explanation to the main clause.
Yes.
Correct.
You'll put your submission in that manner.
Yes.
Then explanation.
Yes.
You notice making it returnable on. When can you file your affidavit?
My lord, in 2 weeks. 2 weeks.
You notice making it returnable on 11th of September 2025. Mr. N. Bulwa accepts notice on behalf of the respondent numbers 1, 2, and 3. Extra copies of the writ petition be furnished during the course of the day. The petitioner herein had participated in a tender process initiated by the respondent corporation on the basis of a notice inviting e-tender dated
1/3/2025.
Hmm?
1/3/2025 tender date.
1/3/2025 for bulk LPG transportation contract by road for the state of Assam and Meghalaya. In terms with the say notice inviting tender, the bidder can offer trucks which are either owned trucks, attached trucks, or proposed trucks. The trucks which are owned, the trucks which are the own trucks are explained in clause 1 capital A of the technical bid of part A. There's technical oblique commercial bid of the technical bid. This will be technical bid. Na? Of the technical bid. The trucks which come within the ambit of attached truck are explained in clause 1 capital B, and trucks which are proposed trucks are explained in clause 1C. Clause Roman 5 stipulates the conditions governing the offer of trucks. Clause Roman 5 small 1 Roman 1 A small a stipulates that such bidder shall quote at least one own truck as on the closing date of tender. It is seen that pursuant to the said notice inviting e-tender being issued, a corrigendum was issued on 6/4/2025. At serial number 5 of the said corrigendum, which stipulated, which were in relation to the details of the PQC documents, there's ownership. There was certain insertion being made which related to, which had a bearing on clause Roman 5 small Roman 1A of the tender conditions. The case of the petitioners herein, as submitted by Mr. K. N. Chaudhary, the learned senior counsel, is that the petitioner submitted their bids of one truck, their bid, which was one truck each, on the basis of an agreement for sale and affidavits in terms with Annexure 40 and 41 of the seller and purchaser, and the other documents, that is the valid registration document and peso license in the name of the seller, with whom the petitioners herein had agreement to sale. However, by a communication dated, by an email dated 29/7/2025, the petitioners were informed that their bid were rejected during the technical evaluation by a duly constituted committee for the reason that minimum one truck owned TT not offered along with quoted ATS truck. This court, while hearing the learned counsels appearing on behalf of the petitioner, inquired as to what is the minimum truck. Mr. Ken Chaudhary, the learned senior counsel, submitted that as per the tender conditions, a bidder can quote a single truck and therefore submitted that the insertion of therefore submitted that in view of the corrigendum whereby clause Roman 5, capital Roman 5, 1 small 1 A have been affected. The contents thereof amounts to an explanation to clause 5, Roman 5, 1 small a. Thereby, by a deeming friction, a bidder who enters into an agreement with a seller by way of an agreement for sale, bracket ATS, and both the seller as well as the bidder submits due affidavit in terms with Annexure 40 and 41, along with the valid registration document and peso license, would be deemed to be the owner of the vehicle in question. He therefore submitted that this corrigendum, which was issued, and more particularly the aspect which had impacted clause Roman 5, 1A, was not taken into consideration. In that regard, the learned senior counsel further submitted that due representations were submitted on 30 July 2025 by both the petitioner, but the same having not been considered, the petitioner have approached this court by filing the present proceedings. Per contra, Mr. N. Borua, appearing on behalf of the respondent, submits that the corrigendum which have been issued, and more particularly the reference to serial number 5 of the corrigendum, is in respect to the attached truck and not the own truck, is his instruction. And under such circumstances, the petitioner's bid was rejected. It is the opinion of the prima facie opinion of this court that a perusal of serial number 5 of the corrigendum which have impacted, which is in relation to clause Roman 5, 1 small a of the notice inviting bid tender, appears to be an explanation to clause Roman 5 small I Roman 1 a, and most particularly when a bidder can bid a single truck in question. Accordingly, it is therefore the opinion of this court that the petitioner has been able to make out a prima facie case for grant of a stay. Have been able to make out a case for grant of a stay, a grant of certain interim directions in the present proceedings. This court further takes note of that if the entire contract process is over, it would have the petitioner would lose their right and the filing of the instant writ petition would become infructuous. Additionally, there might be multiplicity of proceedings. Accordingly, this court, therefore, directs the respondent corporation till the next day not to grant contract in respect to 2 trucks out of 1079 trucks which the respondent corporation proposes to grant contracts till the next day.
Deep breath.
Item 18.
Yes, what is this?
Lordship, this is also similar to the item number 11, Lordship. Non-payment of higher service. Lordship, paragraph 7, Lordship. I have given the details of the bill.
Issue
Page two.
notice making it returnable on 10th of November 2025. Mr. M. Setia accept notice on behalf of the respondent numbers
All the respondents.
1 to 5. Extra copies be served within 3 days. The case of the petitioner is that the petitioner is and the petitioner herein. The case of the petitioner herein is that the petitioner claims to be entitled to an amount of 13,78,822 on account of higher charges for providing his Tata Sumo vehicle bearing registration number
AS01EA 5039. Page 7.
AS01 EA 5039 to the respondent authorities. It is the further case of the petitioner that in spite of various representations they have submitted,
Yes, yes.
the respondent authorities have not made the payment for which the petitioner has approached this court. The respondent herein are directed to file their affidavits on or before 29th of October 2025, liberty given to the petitioner to file reply on or before the next day.
For admission, item 19.
Mr. M. Setia, giving you direction to file the affidavit means filing affidavit. Yes, what is this, Mr. B.K. Das? Herein is claimed as due to which the petitioner is entitled to on account of the conversion of the record. You have been
My lord, we have filed our affidavit yesterday, my lord, probably not on a record. However, his due has been paid long way. On 25/7/2024.
My lord.
how much you have paid?
5 lakh, 19. In one case, 42 lakhs.
Huh?
No, 8 lakhs, 42,520 in item number 19, which is admitted dues.
You have paid this.
Yes.
Have you got a copy of the affidavit?
My lord, no, I have not got the copy, my lord.
Yes,
You've not been
sir.
served.
Okay.
Mr. B. Vokial, the learned counsel appearing on behalf of
Respond number, Deputy Commissioner, my lord.
on behalf of the district commissioner, which one?
My lord, 3, 4.
On behalf of the respondent number 3 and 4 submitted that an affidavit has been filed in the present case to the effect that the petitioner have been already paid the dues as far back as on in the year 2024. To list this matter again on 13th of August 2025. The registry shall bring on record the said affidavit. Mr. Counsel, if on you have received the money in 2024
Ma'am.
and you have not mentioned it here,
Ma'am.
I am not going to allow you to withdraw.
My lord, may I?
I will take action under 340.
My lord, may I just for a moment?
No submission.
20,
13.
Same, my lord. Here also, it has been paid, my lord.
Same order. Affidavit file.
File, my lord.
Be careful.
21,
Only, my lord, on 2nd of August, my lord, they are paying, my lord, 2 installments to me, my lord. That I have the, my lord, account details.
Hello, we'll see.
My lord.
Yes, what is this, Mr. K. Gogoi?
My lord, they have submitted the affidavit in opposition. We'll be filing the affidavit in reply sometime maybe 2 weeks.
Mr. B. Chaudhary, appearing on behalf of the petitioner, submits that an affidavit in opposition has been filed by the respondent numbers 1, 2, and 3 on 15/7/2025. He would like to file a reply. How much time? 2 weeks. Within 2 weeks. List this matter on 15th of September 2025. The affidavit, list the matter after filing of the affidavit.
Okay, yeah, my lord, another case, another WBC is pending. That may be exactly same issue, lordship, same petitioner, same issue. WBC number 649123, lordship.
It's okay.
That may
Let
be.
them file their reply.
Lordship.
Then the matter, list the matter update after filing.
Lordship.
supplementary item 23 to 25.
My lord, verification report has been received, my lords, and the affidavit signed copies are on the way by the chief engineer.
What is the verification?
Verification, my lord, certain amounts are denied, certain amounts are admitted. And it has been countersigned by the chief engineer himself, my lords.
Mr. D. Gogoi, appearing on behalf of the PHE department, submits that the affidavit is in the process of being filed to the chief engineer, PHE department. Full stop. Today.
My lords.
Full stop. List this matter again on 18th of August 2025.
My lords.
Liberty given to the petitioner to file reply if so advised.
Item 22, stay vacating.
Yes, stay vacating. On enterprise. What is this?
IAS will file for the stay vacation. The writ petitioner has approached this court and the on day 1, Lordship may turn to page 57, Annexure 5 of the IA by order dated 7/4/2025. Cooperative part is on page 61. Notice was issued in the interim prayer, returnable so and so. Let the matter be listed and so to reconsider the prayer of the stay of execution of any work by the respondent number 5 pursuant to its selection as L1 bidden E tender dated so and so. I would make clear that.
So work order of respondent number 5 has been stayed.
Yes.
You are respondent number 5.
So I am respondent number 5.
I'm for the government. He's for the respondent.
I am for the petitioner.
You are for?
Petitioner, but petitioner.
I am respondent number
So
5.
it will be so there, my lord.
And I filed the IA lot.
We filed the I.
I don't believe in my order is IA stands disposed of in view of the judgment.
Yes.
I don't have the habit.
Well, let me start, my lord, then.
Huh?
Let me start, my lord. Let me start, my lord.
I give.
Here, for the start, there
CBC, my lord, is relates to my lord JAM portal, my lord tender. The general terms and conditions will be required herein. The main issue is, my lord, petitioner, my lord, is a startup company or firm, my lord. There is a protection given by the central government that, my lord, they need not have to submit any experience certificate. Here, there is a specific condition that it will have to be submitted, and for non-fulfillment of that particular criteria, his bid has been rejected. So, my lord, that JAM, my lord, general terms and conditions are not part of the writ petition. There is a specific clause in one case, my lord, I placed before his honorable court. I had the occasion to go through it. That, my lord, the general financial rules as well as the procurement rules of the procuring state will be applicable.
Which state is?
And it state Assam, my lord. But today I got the, my lord, brief from the government, my lord, to appear on behalf of the state respondents. If this is taken up, my lord, next week, I can place that, my lord, it will be necessary for adjudication of the case on Wednesday or so, my lord, if not inconvenient. Because the entire issue is, my lord, whether that particular
Gogoi, you have to understand one thing.
lordship.
Whenever a matter comes up, this type of matters, I try to dispose of.
I
those
understand. That's
matters
why I'm saying.
comes immediately.
Or lordship may hear us, but otherwise I'm ready.
The only problem which happens is, I'm not available from 25th to for 2 weeks. I'm not there. So therefore, I can't give you a guarantee that the matter would be disposed of.
Then lordship will hear us, my lord, hear the side, other side, my lord, whether it is necessary or not, it will come up then, my lord. If may not be.
His basic case is
Yes,
that in view of the central government, some notification,
yes.
certain documents he is not required to submit.
Yes. Clause
It is
5.
deemed.
My lord.
Your
No, relax,
case-
relax.
Your case is, the GEM portal categorically mandates
Yes.
submission of that document.
Past experience.
And a direction given by the central government
Not
would not have a
applicable.
binding upon the concerned state government,
Lordship.
who will be regulated as per its procurement act and the rules
Lordship. In-
and the notification.
Yes. In fact, lordship will see, my lord, one document on the writ petition, which is a very basis at page 2 to 3. Just one document, my lord. There is-
Yes.
It says, my lord, subject dated, my lord, 37/24, applicability of Assam Public Procurement Act 2017 and Rules 2020 regarding procurement through government e-market, that is JAM. Section so and so of the Assam Public Procurement Act 2017 states that the procedure and details of procurement through the JAM shall be such as may be prescribed by the government. Therefore, it is clarified that JAM guidelines duly issued by the government of India shall hold precedence in all procurement conducted through JAM and over and above any rules of the state government. All head of the department, head of the offices are requested to circulate this advisory to their
So
subordinate.
the government of India guidelines will be preceded,
No, my lord.
will have preceded.
Lord, no, lordship will see, my lord, in the next page, those OMs are there of the central government, which the petitioner is relying upon. Page 225 or 226, my lord, this. 226, lordship will see the first para. It says the undersigned is directed to refer to this department OM dated 25th of July 16, wherein it was clarified that all central ministries, departments may relax condition of prior turnover. It says may. And it is in italics, my lord. Lordship will see, highlighted. Relax condition of prior turnover and prior experience in public procurement to all startups subject to meeting the quality and technical specification in accordance with the relevant provision of GFR, General Financial Rules 2005. My lord, this is not a, my lord,
Then a doubt has arisen.
a doubt has arisen if it makes optional for central ministries and departments to relax condition of prior experience and prior turnover in the public procurement to startups. In this regard, it is again clarified that normally for all public procurements, the central ministries, departments have to ensure that criteria of prior turnover and prior experience of all startups is relaxed, subject to their meeting of quality and technical specifications. However, there may be circumstances where procuring entities may prefer the vendors to have prior experience rather than giving orders to new entities. For such procurements, wherever adequate justification exists, the procuring entities may not relax the criteria of prior experience turnover for the startup. Here, my lord, it is furniture.
But.
But this is not a, my lord, guideline of JAM, my lord. That's what I want to point out. This is not a guideline of JAM.
No, understood, but how do you take care of 223? Clarified that the GEM guidelines duly issued by the government of India is only for, these are for GEM guidelines.
No, my lord, that's what I want to point out is that nowhere
These
says
are
that
not
it will be a
GEM
JAM.
guidelines issued by the government of India.
It's not a JAM guideline.
But the GEM guidelines.
Yes,
issued
my
by
lord, it is
government of
there. It is there, my lord. It is available in the website. There are specific guidelines, my lord, how the JAM portal entire, my lord, is to be executed.
And what happens as regards startup, is there any notification?
That's
Any
from
guideline?
that part, my lord, I will have to check up because I
So
got the
you
brief.
say that this Ministry of Finance
Yes.
notification
My lord.
would have not impact
Mm,
unless
unless it is incorporated in the guidelines or in the, my lord, any, my lord, notification specially for JAM.
unless the government of India have issued GEM guidelines,
Yes,
have issued have issued certain advisory in respect to the
my
GEM
lord,
guidelines.
my lord. That is the entire. If it is there, my lord, then of course you will have a case.
May I submit lordship? The exemption to MSME is articulated specifically denied that it will not be applicable. So the tenderer, the petitioner was well aware of the terms and conditions when he participated. And he admitted that he could not submit the required documents. Lordship will turn to page 27 of Annexure 1 of the writ petition.
Page
27, Annexure 5 of the writ petition, Lordship, for the time being. Annexure 5 starts on page 26, which is the writ document. Page 27. Lordship may come to in the middle, MSc exemption for years of experience and turnover, no. Startup exemption for years of experience, no.
Huh?
So it is not applicable. They are not entitled to receive this exemption.
where documents required for
Page 27. Page 27,
Ah.
in the table, 8 row. On the 8th row, Lordship may find MSME exemption for years of experience and turnover, no.
MSc.
MSc. Then next
MSME
is
is
startup exemption for years of experience and turnover, no. So this is not available to the petitioner. He was aware
Mr.
of
Gogoi,
this.
that day I was taking up one matter of a PHE. I fixed it on 9th of September. The huge implication on the state. You being the edition, although the PHE is appearing out there, I think Mr. I. Pottakur, on the other hand, Mrs. M. Hazarika is appearing. Matter will be coming up on me. I've issued a very, you see, they are claiming that they are SSI. Now, if they are SSI, they say they automatically become MSI. Now, the question is, do they actually become automatically or do they require to submit a memorandum? And if memorandum it is to be submitted to the government, to whom? I've asked them. Because this is the requirement under Section 8. Because at the time when the contract was awarded to them, there was no, they have not given any certificate. These are certificate as per EM Part 2. EM Part 2 are those who are requiring registration under the SSI, under the industrial policies, some benefits. These are EM Part 2. You remember all this. So, can the EM Part be considered to be a SSI registration to the effect that they become MSCP? Because here the moment they are an SSI, the 16% interest, and it was Section 16, the interest is triple the bank interest. I will look at that because this is the implication. Because pursuant to orders passed by me, principal has been paid. Principal is only 62 lakh. The interest comes due as on date on which the petition was filed in 2023. It was 4 crores something.
Yes, I understand. It multiplies, my lord, 3 times. It is there in the statute itself.
Therefore, but if he's not an MSME,
Then you will get.
not getting.
Yes.
So this is because
And my lord, that's whatever that my lord, registration and all, my lord, will have to be there prior to the contract was allotted.
Ah.
That is main, my lord.
otherwise that is not there.
Subsequently,
Because
cannot-
the authorities should also have a notice that these are MSME. Because if you see it's a Section 8. Oh, okay. says that if he is an SSI unit, he has to submit a memorandum within 120 days. Meaning that if you are an SSI, claim the benefit, you file a number. 8.5 says that it has to be issued to the by, state will issue certain notifications. So therefore, this is a very important aspect. Has a ramification on the state revenue.
Dispose of or it will be lifted again. You will lift it again or not, you will dispose of?
No, it's on 9. I've asked them that question. So it's on 9. Actually, there were 4 contempt matters and then there are 2 matters. Contempt, 3 matters. These 3 petitions, one case is 4 crores is the interest, another is 6 crores and so on. So they use ramification. Also, government for Assam, there's no problem. They've got lots of money except for judicial. Yes. So therefore, the question here is as to whether that Ministry of Finance notification would be deemed to be a notification issued for GEM 4. That's the whole gamut of the scope.
But another aspect is that clause 5. Clause 5 of the bid, my lord, page number 29. Regarding past performance, my lord, serial number 5. That is the crux of the matter, my lord, where they reject that page number 29, my lord. Serial number before the column, my lord.
Past
there is a
performance.
past
the
performance.
bidder of the or its OEM
OEM also.
should have supplied same or similar category products for 80% of the bid quantity in at least one of the last 3 financial years before the bid opening date to any central or state government. Then
My lord,
your allegation is that they have not.
they have not considered the OEM.
Now, that is a fact. That is a factual adjudication
Yes.
as to whether they have supplied them. So you say they are not qualified.
They have,
No.
when I have been on this ground, I have not been made qualified. my lord. So yeah, there is no the OEM's qualification has been taken into account. Only single the petitioner's qualification has been taken into consideration. OEM had been excluded because section 5, this rule 5 has not been taken into consideration totally.
Okay, so you say that the
OEM has
you
the
may be a startup. You may be a startup. You may
MESC,
not have
everything.
that qualification. But the OEM
OEM has my OEM, the entire bid, everything has been even startup declaration is given, MSME registration is given, OEM, all the documents regarding to OEM also given. Their anyway, last 4 years turnover is given. That has not been considered.
So you say that you have given the details of the OEM.
Details of that. In
And if you are a startup, MSc or anybody can also give it if he has a year with the OEM.
173 of the GFR, I am also protected. 170 page number, that 170 of the section 1 of the GFR also I am protected for the startup matter. As a startup.
Now let us see one thing. Finally come to 27 again.
20,
Documents required from the seller. You got it?
27, page 27.
Yes. Experience certificate, past performance, bidder turnover certificate requested in ATC. What is this ATC?
Additional terms,
Yes,
conditions.
additional control.
Additional terms and conditions.
OEM authorization.
OEM average turnover. The OEM along with the
In case any bidder is seeking exemption from experience, the supporting document to prove his eligibility for exemption must be uploaded for evaluation by the bidder. Now, you don't have experience or turnover.
this you don't have
because you are a
experience.
startup.
You don't have the experience of mounting to 1,26,000, but the OEM has it. You have to take both combinedly together.
No, no,
OEM.
did you submit? You see a star mark there.
Well,
In case any bidder is seeking exemption from experience of the turnover criteria, the supporting documents to prove his eligibility for exemption must be uploaded for evaluation
yes, yes.
by the buyer.
That's lots we have to straight away come to.
So that means, Mr. Bora, I'm in your favor, I'm telling you, one can presume that there can be an exemption granted to experience and turnover criteria.
Good.
provided you have submitted supporting document.
This is page number 88, my lord. Page number 88.
88.
88. Entire list is given by the checklist of the bidder. It includes serial number 18 and 19 Article 3, bidders MSME registration, bidders startup registration. Entire document has been uploaded. This is the bid document.
When did you get the stay? 7-4.
7-4.
This is for what? Circuit house?
Circuit house, interior material of the circuit house.
Interior?
This is, they
Providing
specifically say that
furniture-
interior
furniture-
furniture works of circuit house. Lokakhana circuit house.
Furniture?
Furnitures and every furniture, everything, that including TV and all these things. Lordship will see the list is page number 26. Long list, 26.
Lordship,
Okay, now, okay. Your bid is less.
My bid,
technically disqualified. Lordship.
technically this way.
Okay.
My bid is less than mine. It's a huge difference. I don't want to disclose it, my lord. Because I have stated in the phrase, my bid is extremely low than the compared
So
to
the
the
technical bid has been cancelled. then
technical
your
bid has been told.
Financial bid not open.
And thereafter immediately they rejected my.
I've been
How much
awarded.
he has quoted?
I've been awarded and I've also supplied also. 80% of the metals have been supplied already.
80% done.
Yes, Lordship.
This, no, not supported by the affidavit of the government. It is not supported by the affidavit of the government. They say supply has been done. If-
We will hear you again.
Lordship, for just time.
Yes, when do
page
you want
218.
it? Mr. Bora, when do you want it to finish it off? You get ready.
I have the record.
Yes.
Entire record of the proceeding, my lord, because both the bids will be necessary, my lord.
So when do you get it?
Any day convenient is not of court.
I'm waiting, my lord.
And there is a stay order. Let us finish it off on 21st or 19th, whichever it's going to be.
Both days.
21st, any day, my lord.
Any day, my lord.
Any day.
When?
19th.
19th তো দুটা বজাত কেইটা আছে তো? আছে? নাই. Okay, 19th.
There are 10 bidders, my lord. 9 were
Hearing
disqualified.
being, this court have duly heard the learned counsel appearing on behalf of the party at length. Mr. B. Gogoi, the learned petitioner advocate general, who represents the respondent, authority, submits that he will produce the records on the next date, lists the matter on 19/8/2025 at 2 p.m. Final disposal. In time orders, if any, is continued with the
Problem.
Much of that.